Please, Your Lordship.
Yes.
Lordship, with the consent of others, sir, I beg to mention item number 29. It's a hearing matter. I am led by Mr. D. Mozumdar. 29, my lord. Can it be fixed on 27th of this month, my lord?
Okay. No objection. Mr.
P. Bora. P. Bora. My name is not on the list, my lord.
Okay. Appearing on behalf of
Mr. D. Mozumdar.
the Mazumdar Council on for the respondent. Praise for listing this matter
On 27.
on 27.
27.
To which Mr. Diki Pangle Lani Council for the petitioner has no objection. Prayer allowed. List this matter on 27.
27. 5.
5. Huh?
Oblige.
Is prayed. Huh? List this matter on. Range.
No, Lord's unlisted more. Civil matter.
That is where we have to mention before this senior bench. So, what's court number 1?
I have made a mention item number 14.
Yes.
I've taken the consent of the senior member also, madam. Matter may be listed on 21st, madam.
Yes, usual after 2 p.m. So I
Madam.
said I will not
But-
detain.
Why it has been listed? Was it not disposed of?
No, it was listed yesterday. The list did not reach single bench.
No, what I
there.
could see in the last order, could you just item 14. Just
Item number
see it.
14.
Yesterday it was listed.
It was yesterday listed, but
And the single bench did not sit. So
Huh.
again, it was relisted
yeah.
today.
no, I just wanted to see.
Madam.
Oh no, this is different one. This is item 14. Here, okay. 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 When do you want to say?
difficulty, he has to
21.
perform some ritual. So
Okay.
either you seek the blessing of God and come back, we'll do the case thereafter. On 21st, Lord.
Okay. Mr. Mato Katana. Praise for listing this matter on 21st. Okay. Admission hearing. What's that?
Yeah.
Okay.
All right.
Interim is there. The interim order passed earlier shall continue till then. Okay.
My lord, with the consent of other side, I beg to mention item 28. 28.
28.
Yes,
My
sir.
lord, I am for the private respondents, my lord.
I am for the petition.
Okay. No objection.
Let the matter come up on 19th of June.
19 of
On 19th of June, your lordship.
June.
Your
You are for petitioner.
I'm for the petition.
Mr.
N. Sharma, your lordship.
N.
N. Sharma.
Sharma. Not
Yes.
counsel for the petitioner.
Yeah, with Dharmas. My friends,
Praise for adjournment of the matter for the and to be listed on 19th of
On 19th
June.
of June.
To which Mr. PD9, huh? 19 June. PD9 Land Council appearing on behalf of the respondent.
And for the state lawsuit.
Okay, and the state respondent has no objection. Prayer allowed. List this matter on 19.
Your lordship, interim order may be continued.
Okay. The interim order passed earlier shall continue till the next date. Okay, of listing. Okay.
Deputy Minister.
deeply.
May it please your lordship. May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 20 of today's list, lordship.
20. Final.
20, lordship. In this matter, I am appearing for respondent numbers 4, 6, and 7, the state of Assam, lordship. We are yet to file our affidavit in opposition in the matter. So, lordship, 2 weeks' time may be granted.
Since the state of Assam was not being represented, there was
Okay,
an order passed. Could give the
okay.
item 20.
No, we have filing the affidavit today, my lords, in the course of today, and a wakalatama also.
You're filing affidavit today itself?
Yes.
Okay,
My friend
Yeah,
is
for
appearing
state of
also.
Assam Lordship, we are appearing today for the first time. On behalf of respondent numbers 4, 6, and 7.
okay. Miss, you are Miss?
M. Devi Lordship.
Think for the first.
5 and 8, the first time. No, Alia had appeared, but the affidavit was not filed, my lords. Some-
Okay, appearing on behalf of respondent number
5 and 8.
5 and 8. When did you file?
20.
Today?
Yes.
Okay. Has filed affidavit on behalf, filed affidavit on
I'm the
behalf.
standing counsel for the department, my lords, forest department. That may be noted. I'm the
Okay.
standing counsel for the department.
Mr. Sharma, standing counsel for?
Honorable Advocate Assam.
Could appear on behalf of the government, respondent numbers 4, 6, and 7.
Lordship,
Yes.
yes, Lordship.
Okay, on behalf of the government of, government of Assam, respondent number 4, 6, and 7. You have filed Wakalat Nama? Have you filed Wakalat Nama? Or what? Are you affidavit? Oh, done. Okay,
Also, there's some audio.
and praise for some time to file affidavit, not yet filed.
Fine.
Okay. Party represented. Let this matter be listed again on 19
19
June.
June.
Okay.
Well, there's an interim order in my favor that may be
Okay.
continued.
The interim order passed earlier, so continue till then.
My deep.
My lord, I beg to mention item number 15, 16, and 17, my lord. Yes, this is connected matter, my lord. My lord, may kindly list this matter after 2 weeks, my lord.
After 2 weeks,
2 weeks, my lord.
you are for? In 15, are you also appearing in 15?
No, my lord, I'm not appearing on 15, but this all are connected matter, my lord.
Okay, who is for the petitioner? Yeah.
Petitioner was supposed, he appears online virtually.
Okay, you are for?
I'm for the respondent number 2.
2 in?
All the, in item number 15, I'm the sole
Okay,
respondent.
so petitioner is not present.
Petitioner is not present.
Okay. Mr.
El Kurdu, my lord. El Kurdu, SPP, SIT.
Are you also praying for the adjournment? He
Lordship,
wants the matter to after 2 weeks.
as Lordship, as
Your
all the
Lordship.
matters of-
Yes,
Mayor, Your Lordship, they are mentioning item number 15, 16, and 17. I am for petitioner in this case, my lord.
okay. There.
No, my lord, I am not praying, my lord, because Your Lordship, without informing, they are praying, my lord. If they want to,
Their prayer is that the matter be listed after 2 weeks. What do
no,
you
my
have
lord,
to
my
say?
prayer is that, my lord, may kindly fix, any fixed date might kindly given, my lord. May kindly fix that matter, my lord, for tomorrow if the council is not available. Why they are mentioning for adjournment again
What
and
is
they are mentioning adjournment, my lord.
you are?
I am
Your-
R. Jagwani, Rohit Jagwani. Rohit Jagwani.
Okay. Mr. Rohit Jagwani, Nana counsel for the petitioner, appeared. for video conference. Mr.
El Kurdu, SPP, SIT.
Present on the request of the parties, the matter stands adjourned for 2 weeks. List is
My lord,
given.
my humble prayer is that, my lord, they may kindly give the fixed date because I am outside from the.
When do you want? When do you want? Give a
My lord,
date.
my PS may kindly fix in next week on 28th or 29th, my lord. Or in
Is it
fixed
okay?
date may kindly give, my lord.
Is it okay?
20, 29.
Hmm.
My lord, on 28th.
Okay, on the request of Learning Council for the parties, let
Kindly continued, my lord.
the interim order passed, if any, shall continue till the next date. Okay,
Much obliged.
My lord, again, each and every date they are placing adjournment, my lord, and they are only praying that interim relief may kindly continue, my lord. Why they are not arguing, my lord, in this matter? This matter is pending since last two years, my lord. I am ready since last 4 months, my lord.
what is this matter about otherwise?
My lord, there are 3 matters, and item number 15, case number 45/25, in which I have challenged the proceeding filed by the wife respondent under the provision of Domestic Violence Act. So it's a petition for quashing of
In
that
item-
proceeding.
You have an objection? You have
Regard-
an objection?
Yes, my lord.
Have you filed?
Actually, my lord, we'll give our verbal hearing, your honor. Verbal submission, my lord.
Okay.
Arguments, because
Okay, on which date? An endeavor shall be made to dispose of the matter. Okay. Okay,
Obliged.
May I please, Your Lordship? I beg to mention item number 11.
item 11.
Yes, leading counsel for respondent number 2 entry is out of station. Therefore, matter may be adjourned.
Your Lordship, on the previous occasion, Your Lordship, they had sought time to file their affidavit, Your Lordship.
We won't.
You are for respondent,
Respondent number 2 entry.
2 and
3 and 4, sir.
3 and 4.
Yes, we won't be filing our
Who is for
affidavit.
the-
They are
We would
praying
be
that we
filing-
won't be filing their affidavit.
Yes.
Okay. Mr. Tijini, Learning Council for the petitioner. Mr.
L. Teni.
L,
Teni. T-E-N-I.
your name is there?
Wakalat.
Okay, Learning Council appearing on behalf of respondent number 3 and 4. 3 and 4, you said?
3 and 4.
Praise for adjournment of the matter to be fixed on.
27. 27 May.
Okay,
Your Lordship.
the Learning Council for the petitioner has objection. Is prayed for, list this matter on 27. Okay,
Your Lordship, if I may, Your Lordship, since they are not pressing on filing their affidavit, that may also be recorded,
okay.
Your Lordship.
then Mr. his name. Submit that the respondent number 2 and 3 will not be filing any affidavit in opposition.
Legality and validity of the order passed by ESP.
Order passed by?
EAC, Assistant Commissioner, without having jurisdiction after an enactment of Arunachal Pradesh Civil Codes Act.
When the order was passed?
The order is at page 42.
Page
42. Yes, ma'am.
Yes.
This was the Prayer was made by me on 18/12/2024. This is Yangbia Raju is me. I have made a prayer before the DC Deputy Commissioner Itanagar regarding the settlement of dispute, land dispute between me and the respondent number 1, my lord. And
You
accordingly,
and respondent number 1.
yes, respondent number 1, the private respondent.
Whether such application is to be made before the deputy commissioner now also, even after,
Because after
even after
because-
civil code act.
Yes, my lord. After 2022 Act, there is a
No, my
amendment.
query is whether the complaint is to be made before the deputy commissioner or directly before the GB or the customary court.
But after amendment 2022,
Hmm.
there is a amendment to section amendment to section 10, my lord, that there is a provision that even
Okay.
they can assist, they can act as a if the suit is the concerned local administrative officer of the area shall continue to facilitate and
Okay,
refer the,
facilitation.
yes, refer the matter to the concerned village.
So the deputy commissioner refer the matter
To the GB Gambura of the concerned village.
okay, where is that order? Deputy commissioner.
That is 8 page 34, my lord.
34.
Yes, madam. 32 is the complaint. Is the respondent number 2. Yeah.
Okay, then
Then subsequently, the page 35, my lord. Head Gamra, he has made an objection that he is having some difficulty to conduct the mail, and accordingly, he recused from the conducting the mail. Page 35, ma'am. On the
okay, so
27th of December.
35 is head GB.
Yes, head.
So this is the head GB of Chimpu Panchayat.
Yes,
So he recused himself.
yes,
From
he
the
recused
case.
himself from conducting
Recused
the
himself.
mail.
Okay,
Yes. Then subsequently, my lord, page 36,
yes.
according to this head GB, that another GB was appointed.
Who appointed the other GB?
Dingdam Chapo. It's
So who
page
appointed?
36. The
Okay.
DC,
DC.
yes, my lord. Yes, he has been appointed.
Okay,
He has been appointed to.
Okay.
Yes.
then
Then accordingly, page 37, on 3rd of February 2025, the appointed GB, he has issued a
someone.
circular dated 30. Conducting the mail, writes a letter to the deputy commissioner
Okay,
stating that the land is with so and so.
was decided earlier.
It was decided earlier.
This is an information only.
Yes, this is an information. Now, basing on this information, I love this order 42, page 42, was passed by the ESC without cancelling its own order.
Earlier.
Yes,
36 is the order.
yes.
Because one GB has recused himself, and
Yes.
after that, this another GB has been appointed to
Yes.
decide the matter.
Yes.
Then what happened?
Then in the middle,
Thereafter,
a circular
the
was
person,
issued.
the GB who recused himself has informed the deputy commissioner
Yes, ma'am.
that the matter after this 36 new GB appointed, thereafter the earlier GB who recused him, he informed that it was already settled.
Yes. But thereafter, the impugned order came up.
Okay.
Basing on this report submitted by the GB who has recused himself from conducting the mail.
Now, what is this order or what?
Yes, page 42.
Order in what?
This is the order deciding the ownership right of
It's not in the same case, it appears. This is for enforcement, means execution. Whether execution petition filed separately,
Yes, it's required to be filed separately.
then,
And moreover, my lord,
so this is
here-
not in the same. This is in execution petition.
Yes.
Where is the execution petition?
In the execution, there is no execution petition, my lord, here. I have not received any execution petition.
How
My
it
lord,
was
may kindly-
registered and how it was registered?
My lord, may kindly.
It's the same number. 33. 17 0. 17 13. 17 13. It appears it's in the same case.
Yes, my lord, the same case.
Yes.
Para 9, my lord.
Para
Page
9.
40. No order, yes.
Yes.
Yes. What happened is that, my lord, the execution court have issued the summons to all the parties for hearing of the matter. Or by with a direction to bring the original.
8. All the parties for hearing of the matter on sense.
Then accordingly, page 10, para 10, my lord, today on so and so, Sri so and so, this all
So this
responded.
is only reference that the DC has issued someone
Yes,
to the parties to appear with all the documents.
yes,
Okay,
they have
then
issued a summons. Then subsequently, my lord, para, page. Came over the land. and-
before him, before the.
Yes, before the executing court.
Okay.
Which is
So
not
in
permissible.
the execution petition, he is asking for the documents.
Yes. By virtue of this execution petition, the respondent number 1, page 54, man, annex the. There is photographs taken on 6/5/2025. He is rampantly developing the land with a heavy machinery. If status quo is passed, madam, then the disputed land will be protected.
Hard, Mr.
S. Chetri. Sumit Chetri.
Chetri, counsel for the petitioner. Staff. by filing this petition under 227 of the Constitution of India, read with Section 151 of the Civil Procedure Code 1908. The petitioner exhaled the order, the impugned order dated 11/2/2025. It's 11/2/2025.
Yes, my lord.
On the ground that the EAC on the ground that by the said order, the EAC, by passing the said order, the EAC has exceeded the jurisdiction, exercised the jurisdiction vested upon its staff. Issue notice returnable, issue notice returnable by 4 days. Call for the record. What is the case number? Call for the record of the SJUD staff. Where is the prayer?
And, page 18, my lord. And page 19 is the.
Suspend the operation of.
Yes, ma'am.
Okay.
Till returnable date.
In the meantime, the operation of the order dated 11/2/2025 passed by the EAC Executive Magistrate Itanagar shall remain state till the next returnable vote. Please this matter after 4 weeks. At 2. Yes.
Wait, please, your lordship. Your lordship, this civil revision is against the order of Deputy Commissioner Lohit, your lordship.
Order of
which-
Deputy Commissioner.
Deputy Commissioner Lohit. He has decided a civil dispute without even drawing a title suit, your lordship. The impugned order, your lordship could find at page number 47, your lordship.
47.
Yes, your lordship.
This is of 2010.
Yes, your lordship. Thereafter, several developments taken place, your lordship. Immediately after this order, your lordship, the petitioner hearing, the respondent number 51 to 54, representing the petitioners, have approached before this honorable court, which your lordship would find at page number 83. Yes, your lordship. There, this honorable court has held, page number 83 is the relevant order, your lordship.
83.
83, your lordship.
Yes.
Here, your lordship, the operative part is at page number 88. 88.
Yes.
Your lordship, here second paragraph. On perusal of Assam Frontier Administration of Regulation 1945, it is also noticed that the said regulation does not provide for any jurisdiction to the Deputy Commissioner to either review or revoke any original decision which had been passed by the Deputy Commissioner.
Yes.
In such view of the matter, impugn order dated so and so, rejecting the aforesaid representation of the writ petitioner by stating that Deputy Commissioner have no authority and jurisdiction to revoke or review earlier order does not call for any interference. If the petitioner are aggrieved by any earlier order of the Deputy Commissioner dated 3/8/2010, an appropriate remedy for the petitioner would be to file an appeal under Regulation 48 of AFR.
Yes. Appeal filed.
However, dismissal, again, liberty has been given to me.
What liberty?
However, dismissal of the said petition may not be a bar for the petitioner to avail any appropriate remedy that may be available under the law.
What is the appropriate remedy?
And that is Article 227, your lordship. We have come under Article 227, your lordship.
What do you understand by the appropriate remedy here?
Here, your lordship,
while dismissing your.
Because by the time
division.
the matter was disposed of, the limitation prescribed.
What is the difference between 227 and revision?
227 does not prescribe any limitation, your lordship. However, there is a rider that the sufficiency of the delay, the cause of the delay has to be explained, but there is no any limitation prescribing by the law, your lordship, and the same thing has been decided by the Honorable Supreme Court in a judgment of 2017 to SCC 748, your lordship. The reason.
See,
Yes, sir.
this remedy, what the liberty is given to you, this remedy, what I could understand is that you can approach before the civil court for proper remedy.
At that time, your lordship, the civil justice was
Basically, under 227, you are again seeking revision only, isn't it? And
Yes, sir.
ultimately, you have to satisfy.
Yes, your lordship.
Hmm,
That
when-
your lordship,
That was dismissed.
that was dismissed on the ground. that-
Dismissed in the writ petition.
Yes,
Then how do we reappreciate?
that was the writ petition which was dismissed, your lordship.
So what is the difference then, basic difference? The challenge itself was dismissed. The challenge of the impugn order
Yes, your lord.
itself was dismissed.
Your lordship, here, your lordship.
Whoa.
Not the original order. Here, this honorable court has specifically held that I should have come challenging the original order, the judgment of 3/8/2010. But since by that time already the limitation period prescribed has been lapsed, your lordship, that's why alternative remedy.
Now, whatever may be, the limitation period, even if the limitation, if the limitation is not applicable, but then you see, the impugn order dated 3/8/2010 has already been dismissed by this court only, by the coordinate bench.
No, it was not 3/8/2010, your lordship.
Then which one?
It was your lordship. Your lordship, before that, to understand this order, I may kindly bring your lordship to page 14, and this was a representation which was filed.
Which was dismissed.
It was 18/11/2010 order was dismissed, your lordship. 18/11/2010 order was dismissed, your lordship.
What is this 18/11/2010 order?
Subsequent after the passing of the order dated 3/8/2010, that was the judgment.
Yes. That was only after 3/8/2010 only.
Yes, yes. That was after this order, your lordship. The petitioner's representative went to the DC for recalling the order which has been passed earlier, your lordship. That your lordship may find at page number 57, your lordship.
Yes.
Page number 57.
Hmm.
Here, an order was passed under the seal and signature of the undersigned regarding ownership of land over Kamuk Taitong area, where at magazine area proposed by MS so-and-so is located, Wakro Circle, Lohit District, to uphold the decision taken by the neutral committee as per the customary law for compliance by all concerned party and disposed of the said case on this and this. And whereas Sri Soto Thalai, chairman, and 49 other members, Wakro Lohit District, Arunachal Pradesh, had submitted a representation to this office on 24/8/2010 to revoke the previous order, which was passed on 3/8/2010. This 3/8/2010 order is the ownership. This is the main judgment order, Your Lordship.
Yes.
In view of the above, I am of the opinion that since previous order was pronounced by this office on the basis of the neutral committee decision, by the order number so and so, and said case cannot be reviewed by undersigned in the office, same official capacity, hence revocation appeal case as submitted by Sri Soto Thalai and others is rejected under the provision of section 48. Against this particular order, they have approached before this honorable court, and this honorable court has observed that they could have approached challenging the earlier judgment order, not the order refusing
Earlier
to
judgment means 3/8.
3/8/2010, Your Lordship.
So you have, that was not challenged.
That was not challenged in the writ petition, Your Lordship.
Oh, have you annexed the petition?
Yes, Your Lordship, writ petition.
Page. Very good, yeah.
Page number 86 is very much clear, Your Lordship. The said impugned order of rejection dated 18/11/2010 is under challenge in the present petition. It is
Just a
reflected.
minute, just a minute. Take your prayer from page 71.
Yes, sir.
Prayer. Both is 3/8/2010 as well as 18/11/2010. Right shall not be set aside and quashed. This is your prayer.
However, in the main order,
And
Your
in,
Lordship,
and in the
in the main order of this honorable
interim
court-
prayer also same.
Yes, Your Lordship, but
Mhm.
in the main order that is at page 86 of this honorable court, it is observed that this on the order of rejection of revocation review dated 18/11/2010 is under challenge.
See, you have been given a liberty, just a liberty to approach or avail any appropriate remedy. This matter a dispute of land. It's ownership dispute.
Yes, sir.
Dispute of fact, isn't it? How do this court decide the dispute of fact, which has already been decided?
Yes, sir. Now, Your Lordship,
You have to approach, probably you have to approach the civil court.
Your Lordship, at that time, DC was only the civil court, Your Lordship. And here, what we are averring here is that, Your Lordship, the manner in which the entire proceeding has been, the matter has been decided without even going
This
as
was
a
decided based on the report of the committee,
Your
isn't
Lordship,
it? This was decided only based
on neutral committee report, Your Lordship.
neutral committee,
Because
basing
this
on
is
the
not the-
report of the neutral committee, not based on the trial,
Yes, Your
isn't
Lordship.
it?
This is the problem, Your Lordship.
Then why don't you approach civil court?
Because, Your Lordship, the order said that I have the remedy either to file an appeal before this honorable court. Because this is,
When this was decided?
it
is
was, it was
3/10, 3/8.
3/8.
By 3/8, the judiciary was already separated. 3/8/2010. DC was no longer the district judge.
Your Lordship, but the Assam Frontier Regulation was applicable that time. That's why probably this honorable court has made observation to that effect, Your Lordship.
What is your explanation on the delay?
On the delay, your lordship, I have
It's
met
been to 15 years, you see, 15 years.
your lordship that I have met at para number 12, your lordship, of my petition, your lordship. Main problem is that, your lordship, the respondent number 51 to 54, representing our village,
Para?
para number 12, at page number 21.
Hmm. Yes.
That the petitioner further back to state that they are the poor villagers who stay in Mawai 2 village in Wakro in the district of Lohit. They entrusted the respondent number 51, being the chairman of the Kande Village Forest Management Committee, a registered society, of which the petitioner were the members too, and respondent number 52 to 54 for agitating their rights and taking legal recourse on behalf of their claims. And accordingly, they entrusted respondent number 51 to 54 that they would file the said writ petition for themselves and on behalf of the members of the said society to which the present petitioner belong and take the required steps necessary in the instant writ petition. It is humbly submitted that order dated 24/1/2017 in WPC number so and so clearly reflects that there were no one representing the respondent number 51 to 54, including the society, and as such the interest of the petitioner remain unrepresented. Though the said society, after the disposal of the said writ petition, became inoperational, but still respondent number 51 to 54, despite being in fiduciary relationship, did not inform the petitioner about the dismissal of the said writ petition. Now, when para 13, your lordship, back to state that on 26 March 2025, this year, your lordship, the petitioner came to learn about the public notice dated 26 March 2025, issued by the DC Lohit district.
You have filed writ petition in the year 2010 itself, and then you see, now you're claiming that they are villagers. How is it possible?
Your lordship, here, your lordship, in my humble submission, I beg to rely on a judgment, your lordship.
What is that?
This is about this limitation period only, your lordship. Supreme, in so far as it regards Article 227, your lordship.
Yes.
Your lordship, para 5 of that judgment, your lordship. Para 4, your lordship. It is an admitted position in law that no limitation is prescribed for filing application under Article 227 of the Constitution. Of course, the petitioner who files such a petition is supposed to file the same without unreasonable delay. And if there is delay, that should be duly and satisfactorily explained. Yes, your lordship, that's why to para 12 we have explained that. In the facts of the present case, we find that the High Court has dismissed the said petition by observing that though there is no statutory period of limitation prescribed, such a petition should be filed within a period of limitation as prescribed for application under section 115 of the CPC. This approach of the High Court cannot be countenanced. As mentioned above, in the absence of any limitation period, if the petition is filed with some delay, but at the same time the petitioner gives satisfactorily explanation thereof, the petition should be entertained on merits. So, subject, of course, to the satisfaction of this honorable court, your lordship.
Yeah, that is what I'm saying.
Your lordship, main thing was that had this order been our knowledge, your lordship, today we would have taken every legal recourse, your lordship.
What are you saying? 2010?
Yes, your lordship.
Order was passed way back in 2010.
Yes,
and then you have immediately filed after in that year itself, you have filed this writ petition. It was pending and you were it was contested.
It was not even I was not represented, your lordship, in that writ petition, your lordship. None appears for the petitioner. Nothing has been informed about it to us, your lord. This is the only last recourse that is available.
What I'm saying is you have filed a petition, whether you appears or not appears, it's up to you.
Yes, your lord.
Why you did not appear, we do not know. But then you have filed. Now you can't say that we did not know, we did not file. It is you who have filed.
It is respondent number 51 to 54 of our village, your lordship. That's why we have implemented them as respondent number 51 to 54.
Same village, claiming the same land.
Yes, your lord.
How can you confuse the court in that way?
No, your lordship. Because they approached before this court in a representative capacity, your lordship.
You have authorized them then?
Your lordship.
It was you who authorized them.
Yes, I authorized them.
Then,
It was me who.
yes, that is why.
Yes, your lordship, but they were under the responsibility to inform me about the dismissal of.
Why you did not ask for say 15 years?
We did, your lordship, but the same thing was kept concealed, your lordship.
That cannot be the point. Okay.
And this is the reason which the petitioner informed me, and that's why we incorporated the same in para 12 of our petition.
Mr. Mr.
And Sharma.
N.
Sharma.
Sharma. Current counsel for the petitioner. Just issue notice. By filing this application under Article 227 of the Constitution of India, the petitioner challenged the order dated 3/8/2010 passed by the Deputy Commissioner, Lohit District, Teju, in what is the number? What is the number of case number?
CRP 45, CRP 45, your lordship. This revision case number, your lordship.
No, the impugn order.
Impugn order is, they have not drawn a case number, however, order is order dated 24. Order dated 3/8/2010.
Number?
Wide memo
Case
number. Memo number.
This is.
They did not draw.
This is not the order passed in any case that appears.
Yes, yes, your lordship. This
then-
is the problem. They have not passed and they have decided the civil dispute without drawing a case, your lordship. This is our plea, your lordship.
In memo number LRE dash 551. Yes, no, just a minute. 551, is it 551, within bracket, PT part, bracket close, stroke, 10 dash 11. Issue notice, returnable by 6 weeks. Call for the record. The petitioner shall take steps upon the respondent by a registered post with AD as well as by usual process within a week from today. List this matter after 6 weeks.
Deeply.
Yes. Yes.
My honor. Your lordship, this application is filed by the younger brother of the accused person in connection with the Dapojo PS 18/2025. The section 170.
Section in both?
This section, yes.
Offense?
Offense is
On
section
section?
117 to and
What is 120?
117 is this grievous hurt. And 103.
103?
Yes, it is the punishment for murder. Your lordship.
What is 103?
Murder, punishment
Murder.
for murder.
Okay, and what is this?
Yes, lordship, this
Three for common intention also. Because there are three co-accusations.
When you were arrested?
Yes, Lordship, I was arrested on the 15th April 2025.
Then
15th April.
April.
Yes.
It's a murder case.
Yes, yeah, actually, Lordship, I will narrate the incident, what happened on that day. Lordship, this
Whether you have filed bail application before the
This,
trial court?
no, this is
Did you file bail application before the trial court?
Yes,
Yes,
Lordship.
yes, yes.
Session court, Lordship.
Session court?
Yes.
yes.
But sir, it's
Rejected.
page- Yes, Lordship.
Yes.
Page
When
32,
it was rejected?
It was rejected on the 21st.
23,
23-4.
Yes, yes.
On what ground it was rejected?
Because that was initial stage.
Hmm?
After the first remand on the 6th,
Still pending.
it was the initial stage. Lordship. Lordship, I would like to read
Involved. Accused person was involved in that of the victim. Weapon also, no? Okay. Whether investigation completed?
Lordship, case study may be called for. It seems like investigation.
No,
has been
no,
completed.
why you have filed this? Because it is still under investigation. What is the new ground you have taken before this court? It's all the same.
Yes,
Session court and-
Lordship, now I think that they are in judicial custody since.
Yes,
30
custody, but then
Now-
at that time also he was under the custody. What is the new ground we have taken before
Yes,
this court?
Lordship, this accused person is a medical patient. He is suffering
Medical
from-
patient, medical, that has also been taken consideration
Yes, he is suffering from this.
at the time of considering the bail application.
This is suffering from this hepatitis B. This hepatitis B is this.
That also probably mentioned.
So it is a spreading kind of communicable disease. So
On the same ground, how do we consider?
now, Lordship, it is almost this accused person in custody for 30 days.
See, that was also considered like, spreading the
No, in the first
hepatitis
remand,
B. That was also considered. After considering only your bail was rejected, why you have come?
no, Lordship, this in the first remand, the bail was rejected because it was in initial stage. Now it is as of now till today, it is 30 days. I think the
30 days in the murder case.
Lordship, I would like to narrate that this.
Mr.
Yes, it is affair.
Mr.
Hitamin.
Planning counsel for the petitioner. This is an application filed under section 483 of Bharatiya Nagarik Suraksha Sanhita BNS 2023. Praying for grant of bail to the accused who has been arrested in connection with Daporejo PS case number 18/25 under section 117 within bracket 2, 103 within bracket 1, 3 within bracket 5 BNS. Start. Call for the scanned copy of case diary. Stop. Ms. Elhage, Lanak, additional PP, represent the state of AP. Stop. Para, list is matter. When?
Lordship,
When came?
please, Lordship. 2021 any date, Lordship. 20 and 21 any date.
28.
21, Lordship.
21. Okay. Matter again on 21. Okay.
Lordship, it is murder case, Lordship. This section 103 is involved. So informant may also be made party, Lordship.
Have you informed? Murder case, informant is necessary to be included.
Yes, Lordship, because it's serious in nature, Lordship.
Serious
It is
in nature,
notice
yeah.
may go, Lordship. Notice may go, Lordship.
Lordship, I was not involved in this incident. After I was arrested after 37 days. Because this is the case.
Trial court will take care of that. So informant is necessary to be included in the murder case also.
Lordship, yes, Lordship, it is serious in nature, Lordship. Jagdish Singh, Lordship, that case law, Lordship. So only notice may be go, whether they participate or not, that is up to them, but notice should go, Lordship.
Then they have to implead.
Yes, Lordship, they have not implemented, Lordship.
You have to implead then in that case.
Yes, maybe.
Implead the
This
victim's family.
Yes.
Oh, the informant. Informant.
Yes,
Needs to be
Lordship.
informant. Okay.
Yes, yes.
Mr. Sensor, implead the informant as respondent number 2. And by filing a corrected the amended course title and file amended course title.
Yes.
Stop the registry shall do the needful. Stop. The informant. You have to take steps upon the informant then, in that case, not possible now then, unless it is amended.
Lordship, if next date fees lordship, by the meantime, they have to take a step, lordship.
Yes. Okay.
They will have to implement the implement as well as take a step.
The petitioner shall take steps upon the informant. Okay. By a register post with AD.
Yes.
Okay.
Applies, lordship.
This is Lordship, the same case.
Similar order.
Yes. You get it.
May it please, your lordship. It's a regular bail application, your lordships. Is a petitioner is a lady having 3 minor children, your lordships. The last one is aged about 4 years. The lady has been belongs from Bihar. Some says page 21, annexer B. As a case of a made out as a cheating, your lordships. She has been alleging as an agent of an government scheme and took the money from the peoples and deposited in the post office, your lordships. And alleging that she being a agent, she has been misappropriated the amount from informant persons, your honor. But the petitioner's husband has been expired in 2024, and she has been already been left in from Arunachal Pradesh in the after the birth of third boy child in the year 2021. She has no way been connected with the entire allegation level against her, and moreover, your honor, already she investigation has
Just a minute. The allegation is against whom?
against the Meena Kumari, who the name FIR name person. Your honor.
And what is the name of the present accused person?
Meena Kumari, along with another Santosh Kumar. We are not for Santosh Kumar. We are only for Meena Kumari, your honor.
Okay, then how she is innocent?
Your honor, she is, I think, is an allegation of that recovery of amount from an agreement. If you
Not
kindly go,
deposited, not deposited. Okay.
not deposited, and
Okay,
already
yes.
and
We'll call for case study.
Yes, sir. You know.
Okay. Mr.
okay, H. Borua, Himanku Borua, H. Borua.
H. Barua, then counsel for the petitioner, staff. This is an application filed under section 483 of the Bharatiya Nagarik Suraksha Sanhita within bracket BNSS 2023, praying for granting of bail to the accused Reena Kumari, alias Reena Kumari, REENA, first, Kumari, alias RINA, Reena Kumari, who has been arrested in connection with 0PS case number 08/2025 under section 318 within bracket 4 bracket close stroke 316 within bracket 5 stroke 3 within bracket 5 bracket close BNS 2023 start. Also, the scanned copy of the case diary okay. Ms. Jenny appear on behalf of the state of LP. This is matter
On 22, your lordship.
on 22.
No, your lordship, can it be on 26, your honor? Can it be on 26? There's some 26.
No, no, sure.
Yes.
No, sure.
Okay.
The
26, your honor.
Yes. No one appeared. Okay. Sound is not coming.
May
Yes,
please, am
Yes.
I audible,
yes, please.
my lord? This is application number 483, my lord, of BNSS, my lord.
Yes, yes, yes. What is the allegation?
Allegation, your
Okay.
lordship, at page 16, my lord. Here, my lord, the alleged incident of rape was alleged to be happened on 18th September 2024, my lord. And that instant affair was lost on 6/1/2025, my lord. There in the affair, my lord, there is no any explanation of delay, my lord. And totally it is false case, my lord. And in that connection, the petitioner was arrested on, my lord, 21/3/2025. Kindly come to my
21? When arrested?
21/3/2020.
Okay.
Page 17, my lord. Page
To call
17, your lordship will find, my
to
lord.
call for case
CD,
study.
Your Lordship.
Okay. Third, Mr.
My lord, S. Hawk, my lord.
S. Hawk, Lana Council for the
S. Hawk.
petitioner. Similar order.
I'll give it
This is
for
an
that, my lord.
application filed under section 483 of the BNSS 2023 for granting bail to the accused. What is the name of the accused?
Rajiv Ali, my lord.
Rajiv.
Yes, yes.
Rajiv Das, who has been arrested in connection with filing case number 01/2025 under section 64 within
One.
bracket 1 of the BNS. Start now. Call for the scanned copy of the case study. What is this? Not of Okay, stop. Miss Same, appear and list this on
23rd, Your Lordship.
23rd, Okay. We are fixing it on 23rd.
My
Okay.
lord. I am obliged, my lord.
Yes.
My lord, this is also regular bail, 483 of the NSS rule. Section involved herein is 103. I will find FIR at page 21. Type copy, yeah, page 21.
Page
21. Type copy, my lord, 21.
Okay.
In the court,
When he was arrested?
10/7/2024, man.
On the same day.
On the same day. Incidents was occurred on 9th.
Where it was?
8.
No, not a 0.
Nalagan, man.
Nahalagan.
Yes.
Okay.
So,
Any bail application filed?
yes, yes.
Where?
In session.
Yeah.
3 times the applications moved. First was moved when before the charge sheet was filed. Then passed.
Now charge sheeted already.
Charge sheeted and evidence has already been taken. Prosecution almost 10 prosecutions, no, not 10 prosecutions, almost all the prosecution witnesses.
Okay. When the incident took place?
Incidents.
10/7.
Yes.
24.
24. And he has
Okay.
been in custody for more than almost 10 months, man.
10 months. So whether now prosecution witnesses is evidence of the prosecution witness is going on.
Going on.
Yes.
And last 2 prosecution witnesses remain. Doctor and IO is.
Doctor and IO.
Yes, my lord.
Whether recently have you filed after that? Have you filed any after recording of the information?
Yes, my lord. After examination of
Where is
informant.
the last order?
Last, yes. Last order is not. Last order is page, my lord, 15. 03, order dated 03/05/25, my lord. Annexure 4, man.
Page?
Page 15.
This is the last order.
Yes, ma'am.
P5.
Yes.
Recently only. It was rejected on what ground?
It was rejected because after examination of the prosecution witnesses, the prosecution has proved that offense was committed by the accused persons.
Okay, he is likely to be convicted.
Yes, likely to be convicted.
Then why you want now only
No, my
two
lord.
witnesses remain?
2 witnesses remain, and I should be given proper opportunity to defend myself, my lord.
They're already gone.
No, my lord. Prosecutions and my defense witness is yet to be taken, my lord.
Okay, defense.
Yes, my lord.
What is
So
the-
tampering of the
What is
witnesses
the
is,
last observation? The ground for rejection,
yes, my lord. Yeah,
only that he is likely to be convicted.
yes, my lord. Yeah, para 8, struck para 8, my lord.
That becomes difficult if the trial court makes some observation, that kind of observation.
In
That-
bail, my lord, bail application, they have concluded.
Then it becomes difficult because before the trial court, when the person knows that he is likely to be convicted, it's very difficult to.
My lord,
Yes,
that's chances of convictions, my lord. Before taking the defense, my lord. So I should be given opportunity to disprove the, my lord, prosecution witnesses, my lord. Anyway, my
So-
Yes, Your Lordship has rightly pointed out, Your Lordship, even in Papu Yadav, it's clearly stated, the apex court has clearly come to the point that even during the defense, the period where the defense witness is taken cannot be a ground for, or neither his
Yeah, that's what
preparation
I'm
and the
saying.
313
That's what I'm
cannot be a
saying.
ground
The
for.
last moment they abscond also, there are
Yes.
instances
Yes.
of abscond.
More particularly when there is a
And
specific.
difficult to get them back.
Yes.
But yes,
Because that cannot be a ground, there has to be a ground, and the submission being made that he has to prepare for his 313 as well as for defense witness cannot be a ground for allowing him bail at this
Well,
point of time.
moreover, absconding. His father is my lord, working as a UDC at the DDH office, and he is accused himself is the was working as MTS
What is his age, by the way?
as 38 years, my lord.
38 years.
Yes, my lord.
Sufficient to-
My lord,
What he was doing,
MTS, my lord, at Prince,
MTS.
multitask staff, my lord.
Okay, he
At
was
Chapita.
working.
Yeah,
Okay.
yes, my lord. And his father is also working at DDS at Zero, my lord, as a UDC, my lord. So this is my lord, notice my this, my lord.
More particularly, no, Your Lordship, no, there is no question of even notice. A very recent judgment of even apex court clearly says that during the process of when the trial is being proceeded, Your Lordship,
Could you produce that?
because calling upon the scan copy of the
That will be, of course, but then court is here, scan copy can be, but that's.
would there be any, because the ground that they are being,
Admittedly, see.
there has to be a ground, proper ground, Your Lordship.
The ground is there, my lord.
What ground?
Because
Defense. That is what she submitted.
now, my lord, even if the observations in the bail order, my lord, regarding the chances of conviction, my lord, that cannot be the ground for rejections of bail, my lord.
Can we just,
Your Lordship, otherwise
See-
can fix this matter tomorrow. I'll be bringing the citation that a very recent judgment of the apex court where it's clearly
what we'll
stated that.
do is, your citation also, and at the same time, let us see how many prosecution witnesses?
There are
been examined?
14,
14.
we,
No.
out of which 10 has already been completed, Your Lordship.
Two more is there, my lord. Two more is
Otherwise,
there.
you have, it appears that you have annexed,
Yes, my lord. Obstruction evidence,
you have annexed.
annex, my lord. All the start from, my lord, so it is start from, my lord, page 56, my lord.
This is deposition of the.
Uh,
Okay, you go through. this.
Informant,
If there is any, go through the relevant portion. You think that there is a prima facie and he is likely to be convicted, also
Well,
you just point out, and then at the same time you produce a citation also. Okay, when do we fix?
Your Lordship can fix this matter, otherwise on
24th, no? First,
21st,
19, even 19.
19th, or 19th, Your Lordship.
My lord, this disease and the accused persons were live in relationships, my lord. So
Because
incidents.
taking into consideration
That
the,
becomes difficult, that
Yeah.
becomes difficult.
even the taking up of the evidence at the point of where he's praying for bail with only specific ground, Your Lordship, that is also to be taken into consideration.
Yes, no.
Difficult, very difficult. Let us see, still there, let him take chance. So, whether you have included,
Yes, my lord. Informant included, my lord. Respondent number 2, my lord.
okay, notice can go there. Okay, hard, Mr. Sorry. Okay, that is, line counsel for the petitioner. Start, huh? Miss Jeannie, non-additional PP, appears on behalf of the state respondent staff. Para. This is an application filed under section 483 of BNS in 2023, praying for release of the accused K. Halu, who has been arrested in connection with, who has been arrested and in under trial in connection with case number 23/2024 in Nahal NLG PS case number 71/2024 under section 103/58 of BNS. What is the case number?
Session case number
Okay,
Malad 20
pending trial before the court of the
session UPA
session UPA in session case number
23 Malad
23,
23 of 2024.
2024. Start. So no need to call for the
Not necessary, Your Lordship.
Well, since notice, at least notice can be issued Malad. On the merit, it can be hard on merit Malad.
issue notice.
And I think man, this can
issue
be
notice.
required Malad.
Since Miss Jeannie
PCR will be required.
is appear on behalf of the state respondent, no notice need be, no formal notice need be issued to the state respondent. However, the petitioner shall take steps upon the respondent
Malad,
number
throw
two.
PP Malad.
To draw,
PP Malad.
draw.
PP. Public prosecutor Malad.
Lordship,
Okay.
if the step is being taken from from the concerned court, Your Lordship, because it's all in the process of the trial, Your Lordship.
Okay. They are staying at the address is at 0.
Zero Malad.
Okay. Steps upon the respondent number 2. So the concern
Jurisdictional court, Your Lordship.
jurisdiction code. All 0. Okay. Concern jurisdictional court, that is the chief judicial magistrate. 0. Okay. To be routed through PP.
Not
Officer-
through a registry, Your
No,
Lordship, not
through-
through us.
okay, okay. List this matter again on then
19th, Your Lordship.
will it reach on 19?
Your Lordship, 19 more particularly will deal with, Your Lordship has already.
If they argue on maintainability, Malad, then it is
No,
not
no, there is
required-
no question of
then-
maintainability.
Then it is not required for the calling of TCR Malad. If she want to argue on the merit, TCR will require Malad.
No, Your Lordship,
This can
I'll
conflict
just
with
clarify to that. First of all, I'm not arguing on maintainability.
So,
I'm
this-
my argument is purely on what ground they have come before this court, Your Lordship. Or is that ground really viable to be enough to grant bail, Your Lordship, at the stage of completion of PW's depositions?
I leave up to my lords, my lord. Otherwise, on merit, if it's to be disposed of merit, TCR, scan copy of TCR will require, my lord.
Okay.
If
That's-
they ask,
Now,
argue
after-
for the
after
maintainability.
notice, no? So now this call for the scanned copy of file go to. Okay, we'll just see.
Yes, sir. How like,
In that case, Your Lordship may fix this matter on
21.
29th, Your Lordship. Because TCR, it will take time. Already a bulk of witnesses as well as the documents in the CD has to be taken.
session court only, yeah, my lord. 21st, my lord.
Does not matter, on 29th,
21st or
Your Lordship,
22nd, my lord.
or otherwise on 26th.
26.
Because, yes,
So that it will take that long. We'll say then
21st, my lord. If TC are not come, then we'll post.
therefore, Your Lordship, why do wait on 26th?
22.
On 26th, Your Lordship.
22, my lord.
Because the court does not only deal with certain cases, Your Lordship. Now the scan copy has to come, Your Lordship. Your Lordship can fix this matter on 26th in that case, Your Lordship.
Dapo, from Dapo, it was fixed on 21st.
Because we have to wait for notice also as per their own submission, Your Lordship. 22 notice will not be
If not
given
come, the date
because-
will be posted again, my lord.
yes. So instead of posting it again, why not on 26th?
15.
How you can say it's not
That's not, notice has to be given.
Not completed.
15th, your lordship, notice has to go, your lordship. Your lordship is also calling for TCR. This matter may be fixed on 26th.
22nd,
Oh, no, 26.
Yes, sir.
26th. No problem.
Deeply obliged.
This matter has to be placed before the appropriate bench. Appropriate, before the appropriate bench, yes, lordship.
Your lordship.
Okay,
This is a bail application.
Lordship may kindly come to page number 14.
okay, rejected earlier.
Earlier direction has been given and it was disposed of. So it also comes under the notification.
Disposed of by
Justice Y.
Okay.
Longkumar.
no, whether the bail was considered, heard and considered.
Yes, my lord, may kindly go to the notification 27, my lord. Even if it is withdrawn, even in such case, your lordship, it has to be placed.
It has to
before-
be.
Yes.
Okay, then in that case, no option. Okay,
Notification 27, my lord.
okay, no problem. Let this matter be placed before the appropriate bench. Okay,
Obliged.
May it please your lordship.
Yes.
This is a petition for quashing of an FIR by mutual consent of the complainant and the accuser.
mutual.
My lord, they've entered into an agreement for mutual settlement. The agreement is in annexure number 5, my lord.
What was the
My lord, the FIR was in Rupa PS.
offense, huh?
Rupa, West Cumming.
What is the offense?
My lord, it is 420, 406 and 403. Cheating, breach of trust and misappropriation of property.
What is the status of the case?
And it has been sent for inquiry, my lord. It has not been case.
Inquiry?
My lord, to SIC Itanagar, it has been sent. As per the last status that I have, my lord.
It is still under investigation.
It is under investigation.
My lord, in fact, this agreement itself is a defective one because the informant is not been made as a party and the concerned office.
Informant is different.
Informant is different. My lord will come in the come to the inquiry report which has been submitted by the SI, which is later on he will become the complainant in this case. He is not even the party in this case. Lordship may kindly.
Informant has to be impleted.
No, my lord, he is the director of a company. The company has been made a party, and subsequently, my lord, the company has, my lord, means come to page number 24. The company has appointed another person to be the authorized person for dealing with this matter. So, my lord, the complainant is a company. The complaint he has sent is also
who is the applicant on behalf of the company then?
my lord.
Yeah.
My lord, the company itself has been made the party, my lord.
No, who is the informant? Let us see first. Who is the informant?
My lord, inform me, my lord.
Where is
My lord,
the
please come to page number 10, annexure number 3.
Page 10.
Page 10, annexure 1, my lord.
Okay.
This is the
Gurajada Uday Krishna.
Yes, my lord.
He is the informant. Then
No, not
no, my lord. He's the
accused.
my lord.
Alleged accused, my
This has
lord.
been sent by the my lord. May see the letterhead. Devi Energies.
just a minute. Just a minute. Where is the FIR?
My lord, FIR is in annexure number 2, my lord.
Annexure?
Annexure 2.
2.
My lord. Page number 15. My lord, may see the address. Devi Energies Private Limited.
6 is the complainant, my lord. Column 6. Column 6, your lordship will find in page number 15. FIR. Column 6, complainant informant. Deveso Chaitam.
My lord, he has acted as the.
Where is the Devesu Chatham in the petition?
My lord, he has acted as the director of the company.
No.
Okay,
He was
where is
the inquiry
where is the
officer, my
director?
lord.
Where is the director?
He was the Deveso Chaitam was the inquiry officer. Your lordship, everything will be clear from page number. Your lordship may directly come to page number 19.
He's the investigating officer.
Page number 19.
Inquiry report.
Yes. Here your lordship will find everything. Everything is very clear here.
Hmm.
The inquiry has been made on the basis of the complaint received from D.K. Thungdok,
Okay.
director. And your lordship, it is very clear that FIR can be lodged by any person. And even if it filed in the name of company,
No,
it will be by the authority.
according to you, who represents the informant? in
My
the
lord,
petition.
according to me, my lord, the complaint has been registered by the company, my lord, to its director. And
Who represents director here in your petition?
in my petition, my lord, petitioner, it is, my lord, may see the affidavit, my lord. It is, my lord, may see Adivi Lila Nagraju, my lord. He has also signed.
Petitioner number?
My lord, he's petitioner number 5, my lord. Petitioner number 5 is the company itself, my lord. I have made the company itself a party.
No separate affidavit also, my lord.
Company. So the person who earlier lodged this FIR is no longer in the company.
My lord, the persons who were accused are no longer in the company, my lord. The persons who were accused are no longer in the company. The company.
No, not the accused, the informant.
But the informant is the investigating officer, my lord. But the complaint was lodged by the company through its director. In its office.
Okay, who is director?
My lord, director is
D.K. Tundap.
My lord, let me see the complaint page number.
You have to, I think, implead the person who lodged the complaint.
My lord, he is acting on the capacity of the director itself, my lord, because.
So who is director now?
My lord, it is, my lord, let me see. This is the D.K. Tongdok, my lord.
Then you have to implead him.
Well, if I may, my lord, if I may take you to page number 24, my lord, for a moment.
What is that?
My lord, this is the extract of the minutes that the company has resolved, in which the director D.K. Tongdok has only signed, my lord, in which A.L. Nagdaju has been appointed as has been authorized on behalf of the company to settle this matter. This has been signed by D.K. Tongdok, my lord.
Let him say that I no longer representing and Mr. So-and-so is representing.
If I may, my lord, take your lordship to the agreement for a moment. The
Yes, agreement was signed by whom?
Well, settlement
Whether
agreement has
D.K.
also been
Thungo signed.
Yes, my lord. It has also been signed by A.L. Nagraju only.
Now then D.K. Thungo has to say that I have also signed this agreement.
He has not
Isn't it?
signed.
My lord,
He has not signed. He is not party in the agreement.
My lord, because after this,
He is not in the party.
Yes,
He's not a party in
He's not a party because, my lord, he is acting as the director of the company, my lord.
Now, in a criminal case, you see the person who knows the fact, he has to appear before the court, not the succeeding director, succeeding person.
My lord, if I may take.
Yes, please.
My lord, this case is completely of a commercial nature. They have been alleged that they have taken purchase from vendors at a higher price, and then
Maybe.
So, my lord,
let him say that he is no longer there, and he has not. Let him also say.
Oh, my lord.
Okay.
My lord, may allow me to implead.
So that will let us ensure that later on he doesn't come.
And my lord, I would
And say
like
that
to
I was not a party.
point out one aspect, your lordship. Your lordship may kindly come to page number 23. The second para, your lordship. Here, the IO has referred to SIC, meaning thereby, your lordship, the allegation of corruption is prima facie there, your lordship, after inquiry. If PC Act comes, your lordship, then there is no question of quashing, your lordship.
This is a private company.
Here, your lordship, private company, no doubt it's a private company dealing with the public works.
Why it was referred to them?
Hence, due to the technicalities involved in misappropriation of fund of the company by the alleged accused person suspected to be done at a very large scale in the case, I request the kindly authority to forward the case to SIC Itanagar for thorough and more profound investigation to be carried out in the state case. So now here, after inquiry, the complaint has been filed with Deveso Chaitam, your lordship. Now he is also the informant, your lordship, in this case. He should also be made as a party.
There will be no problem. You just implead them and let them also say, okay.
My lord.
And secondly, my lord, affidavit has to be shown by all the respective accused. Only one has.
Affidavit? No. Affidavit has to be signed by all.
My lord,
only one.
My lord, this has been signed by the complainant director, and the others have authorized it.
This is a
criminal
case, your lordship.
My lord, if I may be allowed to bring it through another affidavit, my lord, he has been authorized. If I be permitted to do that, I'll bring that also on the court.
Adibi Lila only. Yes.
My lord.
Okay. Now, what is the remedy?
They have not annexed, your lordship. They has not shown affidavit
in supporting of this petition, Your Lordship. They have to,
I think you better.
it's better to withdraw it, file and press.
Withdraw and file afresh.
My lord, may kindly consider, my lord, these persons are in, not here, my lord. It takes a long time, my lord. If I may be permitted to bring additional affidavits which they will sign.
Now
I
you
can
see,
accept,
the
my lord.
affidavit is also to be then, this.
Because, my lord,
It has also to be.
they have signed separate vakalatnamas,
See,
my lord.
they are in the petition, it has to be. No, is it possible here?
And there is a, my lord, notarized document which they have all signed. There's no conflict or there's
No,
no
I think
dispute regarding that.
this is,
my lord.
only one person has signed. You better
My lord.
withdraw, you better withdraw and file afresh.
My lord, will kindly allow me to file a affidavit bringing,
And then again, you have to implead
I'll
the
do both,
person.
my lord, because
And he need to be the, if you say that it is a joint petition, then he need to be impleaded as a petitioner number 6.
Tungon also and Devaso Chaitam also. Because, Your Lordship, subsequently the inquiry has been conducted and basing on that only the FIR has been registered. So he is now the informant, Your Lordship. And if any trial commence, he is answerable as a prosecution witness, Your Lordship.
Yes. He will be called, not the one, this Adibi. What is this? Adibi. Not Adibi. Adibi is not required in a criminal case.
Yes, Your Lordship.
I think you better withdraw. Okay. Mr.
RB Goswami, my lord.
Nana counsel for the petitioner wants to withdraw this petition with the liberty to file afresh. The prayer is allowed. This petition is dismissed on being withdrawn. Okay.
Public.
With liberty as prayed for. Huh? Okay.
May I, Your Lordship?
Yes.
Your Lordship, this criminal petition has been filed by 2 numbers of petitioners. Petition number 1 being the alleged accused and petitioner number 2 is the informant. Now they've prayed for quashing and setting aside of the charge sheet and the criminal proceeding pending adjudication before the court
What's
of
the
learned.
charge sheet? Trial begun. Whether the trial of the case started?
Yes, the trial is going on before the learned court at CJM Teju.
What is the status?
The next date has been
Status
fixed
of
for
trial?
evidence. Yes, the next date has been fixed for evidence, Your Lordship.
Evidence?
Yes, Your Lordship.
Evidence already recorded, some of the
No.
evidence? Not yet?
Not yet.
Not yet started. What is the
The
section
parties,
involved?
yes, the petitioners,
Just
279
what is the
and
offense involved here?
279 and 304A IPC.
304.
304A IPC.
304. 4A.
Yes, Your Lordship.
Okay. So that case.
Yes, that case.
Who is the informant here?
Petitioner number 2 is the informant.
Who is the informant?
The wife of the deceased, yes.
Wife. One is accused. When the incident took place?
5/2/2024.
24. Record can be called for?
Yes, Your Lordship, record may be called for and the further proceeding may be stated.
Your Lordship, I have annexed the order, the last order, which has been certified by the Sharisadar itself, Your Lordship. The case may be disposed of, Your Lordship. The case may be disposed of, Your Lordship. The deed of settlement which has been entered between the parties, I have annexed it, and the last order
Case
of
will
the
be disposed of, but let us see the record. Okay. Which court?
CJM Teju.
CJM Teju.
I have annexed the last order also, Your Lordship.
Last order?
Yes.
Where? Page?
55, which has been certified by the Sharisadar.
Page 20?
55, page 55.
Someone already issued.
Trial commencement.
Okay. Miss
M. Gogoi.
M.
Gogoi.
Gogoi, Lana Council for the petitioner. This is an application filed under section 528 of BNS 2023, praying for passing of the charge sheet number 22/2024, dated 29/8/2024, under section 279/304A IPC, and corresponding case, GR case number 32/2024, arising up is okay, arising out of Teju PS case number 11/2024, pending trial before the Court of Chief Judicial Magistrate Teju staff. Issue notice. Call for the scanned copy of the GR case number, scanned copy of the trial court record, staff. Since Mr. P. appear on behalf of the state, no problem.
Interim.
No, just a minute, No, not required, that also, So, list this matter, when, Mr.
Maybe after, my lord, 2 weeks.
Lordship, a specific date may be given.
Okay, you just.
30 of this month.
When, after 2
30
weeks?
May.
After 2 weeks, that means 30, your lordship, as per her convenience, it's okay, fine. She's coming from a
Okay.
outstation.
When do?
30 May.
30 of
30
this
May.
30.
30. 30.
30.
Yes, sir.
Okay. 30 May, stop. Fab. In the meantime, the further proceeding of the GR case number 32/2024. Arising out of Teju PS case number 11/2024 said remain stage, Okay.
Obliged.
List is matter after, on 30, 30. Yes.
My lord, this is the case relating to Pasar Police Station PS case number 15/24 under section 66E of IT Act 2000. And this criminal petition filed under 482 of CRPC 1971. What's if the fact of the case is that here the petitioner is a senior nursing officer. Petitioner is a senior nursing officer, and the allegation is that the petitioner has transmit and the nude image photo of the informant. Now, come to the
service service report has been annexed.
Thereafter, any order passed by?
Yes, my lord. In the last order, it
By
was.
which order?
My lord, in the last order, it was fixed for admission today.
Okay, let us see the impugn order. What is the impugn order?
Impugn order is page number 26, my lord.
Page
Number 26.
26.
My lord, the entire crux of the matter is simply who is entitled to receive the debt and securities that has been left by the deceased Gocham Taga. So
This regarding the entitlement of the
debt and
benefits,
securities, my lord.
debt benefits, security. Okay. So
Now
you are otherwise
I am for the appellant, my lord.
That is
The first
the-
wife.
this is wife,
Yes, my lord. The first wife.
first wife,
Yes, my lord.
and then who are these other respondents?
The respondent number 2 is respondent number 1 is
Just a
the
minute, just a minute. Huh. You are for the first wife.
yes, my lord.
Of the deceased. And what about the who are these respondents?
Respondent number 1 is the so-called second wife. Respondent number 2, 3 are the sons of respondent number 2, 3, and 5 are the sons and daughters of between the wedlock between me and the deceased.
Hmm? Sons and daughter of you and the deceased.
Yes, 2, 3 is the son. 2 and 3 are the sons of
Your son.
yes, my lord. And 5 is my daughter, my lord.
And what about 6?
Oh,
sorry, 4.
4 is the mother of the deceased.
Mother of the deceased.
Yes, my lord. They have been a pro forma respondent because in this appeal,
Two is
2 is my son. My son.
3 is also son.
Yes, yes, my lord.
Okay, and then 4 is
4
mother.
is mother of the deceased, my lord.
Okay.
5 is the daughter, my lord. My lord, we have made them pro forma respondents. 2, 3, 4.
And one is
the so-called second wife, my lord.
wife. Not contesting.
We're contesting, my lord.
Hmm?
We're contesting. We're contesting.
No,
that is the
here-
whole.
Here before this court, she is not appearing.
No
No one
because
represent her. Here before this court, no one represent her.
yes, my lord. We have already served a notice, and my lord, it's a very low stake matter, my lord. Only 13,000 rupees is left, my lord. Therefore, it seems that parties are not interested. It seems like
Okay.
respondent number 1 and respondent number 4 are not interested. Therefore, in the last date,
You are for 3,
2, 3, and 5.
2, 3, and 5.
Pro
Not for
forma
the 4.
respondent.
Not for even for the 4.
Yes.
4 is also not contesting.
yes, my lord.
So are you contesting?
No. I don't.
Okay. Now, your grievance is?
My lord, so in this appeal, we're confining ourselves merely to issue number 1. Issue number is page number 32, my lord. Page number 32. Kindly come to page number 32, my lord.
The impugn order is at page 26.
Yes, my lord. And the issues framed are at page number 32.
Page
32, my lord.
yes.
32, issue number 1. Whether the plaintiff, namely Srimati Rotomyama, is the legally wedded wife of the deceased late Gocham Taga, or whether the defendant Srimati Sharing Dikhi is legally wedded wife of deceased Gocham Taga. This is the issue we're confining ourselves to.
Okay. So you are your name?
I am Srimati Rotomyama.
Yeah, Tom. Okay. And then the other one is
Srimati Sharing Dikhi.
Sharing Deke, but Sharing Deke is not contesting now.
Yes, my lord.
Just a minute, huh? Okay, not contesting. Okay, this is issue number 1. Then
Yes, my lord. We're merely confining ourselves to this issue only, my lord, in this appeal. So this issue, my lord, in this order, in this judgment, the lower court, the learned lower court below has passed that I and the deceased husband separated in the year 2010, and therefore, respondent number 1 is the legally valid wife of the deceased. To come to this decision, my lord.
living with the second wife.
Yes, my lord. To come to this decision, my lord, the learned court below has relied on a document. My lord, there is annexion number 6, page number 140, my lord. page number 140, annexure number 6.
Now, what about the other, these other issues are not in dispute?
Yes, my lord, we're not disputing them, my lord.
Okay, only your.
That's why we have made
you are
3,
confined
4,
to the
5.
Number one.
Yes, my lord. 2, 3, 4, 5 performer, my lord. My lord, kindly come to annexure number 6. It'll be very, it's a very simple matter, my lord. Annexure number 6. Annexure number 6, 140. Because this is the document that has been relied on by the learned court below to
140.
140, my lord. Annexure number 6.
140,
my lord.
40.
My lord. Annexure number 6, my lord. My lord, this is a certificate that has been granted by the Gocham Society, or a village authority, wherein they have said that I and my deceased husband were separated in the year 2010, and thereafter I have remarried and so on, and hence I am not entitled to receive the legal.
Hence you are
Hence,
not entitled.
She's not a legal heir of late Gocham Taga.
She is not a legal heir.
Yes, my lord.
So according to this certificate, you are no longer a legal heir.
Yes, my lord. This is what. Yes, my lord. This is what the learned court below has relied on, and that is what we're challenging particularly because this order, this certificate has been given legitimacy by the lower court under Section 40 of the AFRA Act, my lord. Under Section 40, because this has no, my lord.
What is that?
Section 40 of the AFRA Act is power of authorities, my lord. The village authorities shall try all suits without limits of value in which both the parties are indigenous to the Union Territory of Arunachal Pradesh.
What is AFRA? AFR.
AFR, my lord.
Okay.
Assam Frontier Administration of Justice Regulation, my lord.
Is the 40 still? 40 has not been. Okay.
So this is what the lower court has relied on to give legitimacy to this certificate, my lord. Now, under Section 40, to give power to Section 40, there's multiple procedures and multiple layers before coming to a decision, my lord. For instance, Section 44, hearing of cases. Section 44 of AFR, hearing of cases. All suits tried by the village authorities shall be decided in open darbar. This has not been complied with. Section 44, Clause 3. After hearing both parties and their witnesses, if any of the village authorities shall forthwith pronounce a decision that has not been complied with, it has not complied with multiple procedures that has been laid down in the AFR Act, my lord. And my lord, kindly peruse the document a bit more closely. It has no date as well. No notice was served to the. No notice was served.
No, according to you, the Alana Trial Court has decided.
Yes, my lord.
The case based on this certificate.
Yes, my lord.
Issued by
the
PIs and
issued by village authorities.
Village authority.
Yes, this is
when this was issued? 2020.
No date, my lord. No date. That is why we were not even a party to this. This has come out of nowhere during it came out of nowhere during the trial only, my lord. It has no date. It has, but under Section 40, the lower court granted the legitimacy. But under Section 40 has to comply to Section 40.
No, just tell me whether the respondent number 1 has also a children with the deceased.
No, my lord. No, my lord.
No.
No, my lord.
So no need to only C. Okay. So the trial court has decided the case based on this document.
Yes, my lord.
Where is the decision? Let us see.
Para number 16. Wait. My lord, para number 16.
Para 16.
My lord, yes, my lord. Oh, sorry, my lord, page number 36, para 16. Assam Frontier Regulation 1945 recognized the village authorities and empowers the village authorities, i.e. Gaubura, and head Gaobura for determination of sub-criminal offences and civil disputes among the tribesmen. Section 40 of the Assam Frontier Regulation 1945 provides that village authority has jurisdiction to decide all kinds of disputes, civil disputes. The dispute relating to marriage or divorce is also civil dispute, and as provided under Section 40, village authority has jurisdiction to decide such dispute. In present case, the village authority of Raga headquarter, including Raga 1, Raga 2, have certified the plaintiff number 1, Srimati Rotam Yama, separate from late Gocham Taka in the year 2010 due to disputes arises by Srimati Rotam Yama, and she never returned back to late Gocham Taka and remarried with Sri Dorju Kandu and living with him as husband and wife. My lord, there has been no evidence that I have remarried or I have separated, my lord. That exhibit is not disputed by the plaintiff.
Just a minute, sir. So there were a plaintiff number 1. He's remarried to somebody else.
My lord, there has been no evidence as to that. And my lord, there is no evidence to prove that, my lord. And even the learned court below has recognized that fact.
You did not dispute this certificate before the trial court.
Your Honor, it was disputed orally, but it was disputed orally, my lord. I have confirmed.
The observation says that you have not disputed.
I have confirmed with the advocate for in the trial court, my lord. It was disputed by the advocate, my lord. But however, it was not recorded, my lord. It's not recorded and not observed.
Okay.
My lord, tribal marriages should not be as simple as to be voided by a group of men coming together and then passing a decree as to that effect, my lord. It has more sanctity than merely just being...
Have you challenged that certificate then?
My lord, that certificate, we are challenging, my lord. We have challenged, my lord. We have challenged it in this order because this has no date as well. We do not know when it was passed also. This has completely violated the procedures of AFR, my lord. Kindly peruse the document. There's no date also, my lord. We don't know when it was passed. There's no date. There's no...
Whether the record was called for?
Record was called for, my lord.
Record is there. The judgment says that you did not dispute.
My lord, it was disputed, my lord.
Then we need to see the cross-examination if you had disputed. Have you annexed those?
Yes, my lord.
Deposition also?
Yes, my lord.
Where is, who stated, who exhibited this?
This is exhibited by respondent number 1.
Okay. Where is the deposition and cross-examination of the respondent number 1?
Respondent number 1 is, my lord.
Respondent number 1 means?
The Srimati Sringdiki.
Okay. She was, this case was dismissed then?
This was dismissed in the order, judgment was passed in the month of October, 14th October 2024, and decree was passed on 24th October 2024.
Who is the plaintiff in the trial court?
Sorry, my lord.
Who was the plaintiff there?
I was the plaintiff, my lord.
Okay. So this was not a dispute, the dismissal. Is it the dismissal order? The impugn order?
No, my lord.
Giving some percentage?
Yes, my lord.
Now, what about this? The percentage, whether it was given?
Yes, my lord. 25% to each of the 20% to son, 20% to both the sons and mother, and to the respondent number 1. We're challenging merely the 25% that was granted to respondent number 1. My lord, the second limb of the argument, my lord, is that there is no valid marriage between respondent number 2, respondent number 1, and the deceased, my lord.
Now, then in that case, this percentage division of this percentage also will go then if you're challenging that. You say that you are not challenging the other issues. They are given to the respondent. So what remains? You said 13,000 remains in what?
In the debt and securities
what
that is
head,
left.
huh?
That is the securities that has been left, debts that has been left. Only 13,000 in the bank account of the deceased, my lord.
After this judgment, rest of the amount, all those the benefits have been divided and shared between the parties.
25% to the
Yes.
respondent number 1,
Hmm.
2, 3, 4, 5, or given 25% each.
2, 3, 4, 5.
Yes, 1, 2, 3, 4, my lord.
Okay,
Sorry.
one also.
Yes, my
She
lord.
also
That's,
got her share.
yes, my lord. That's why we're challenging this, my lord. Only with respect to her share.
No,
my
no,
lord.
no. What I'm asking is whether the share has been already given or not yet.
Not given, my
Not
lord.
yet.
Still in the stage of vigilance, my lord.
Then probably since you say that it was disputed, then we need to call for the record. What do you say?
The record will be required.
Record otherwise it will be necessary because you say that you have disputed.
Records already came. So
You can call for the. Because whatever the amount may be, ultimately there has to be disposed of on merit, isn't it? With justification, just only because she is not appearing doesn't mean that it will go like that. Okay. So
29th, it can be fixed on 29th.
third, Mr. Patil. Oh, you are Mukbang Patil, land counsel for the appellant. Also heard Mr. Gatso, land counsel Gatso, appearing on behalf of respondent number 3, 2, 3, and 5. 2, 3, and 5. No one appears on behalf of the respondent number 1 and 4. One also received the notice.
Yes, my lord. An affidavit is filed to end, my lord.
Okay. Where is your affidavit? The office note dated 05, 8/4/2025. Oh, just a minute. We will not mention the respondent number also here in the office note. What we will do is the record reveals that after taking steps upon the respondent number.
Service has already been completed, my lord. Service has already been completed.
It was recorded.
Yes, it was recorded in the last order, my lord. Last
Mm.
order, my lord.
Okay. Okay, no one appears on behalf of the respondent. No? Okay, in this case, the record, trial court record would be necessary for proper adjudication. Start recording, let the record, the trial court record be called for start. List this matter.
My lord, 29th of
29, will it come? Where, this is from which court?
this is from Bomdila, my lord.
Bomdila, will it come by 20?
Yes.
It's never.
It will be not a scan copy.
Then also.
It can copy
Okay,
here.
okay. Okay, list this matter. Again, 24.
29, 29.
29, okay, 29. Okay.
Much obliged.
This, my lord. My lord, this is bail application under section 483 of BNSS. Applying for regular bail for accused persons Oling Lego, who was arrested on 5 April 2025. And since then, Your Honor, it is accused person in judicial custody. The charges level against the accused person is 21 small a and 27 small a of NDPS Act. And these are the 21A is the for the possession, and 27 small a is for the consumer. And
21A is
for possession. Possession, possess.
Amount
0.12 gram.
This is a small.
Yes, very small quantity. And Your Honor, my lord, I have filed bail application before a special court for NDPS Act. It was rejected, but Your Honor, co-accused was bail was granted, and I have annexed the same, Your Honor. And since Your Honor, 07/04/2025, accused person is in judicial custody. It's more than 30 days he is in judicial custody. So further detention in the judicial custody is no more required. And this accused person is willing to undergo, Your Honor, rehab, detoxification and rehabilitation, Your Honor. And the applicant petitioner is the father of the accused person, and he is also, Your Honor, ready to take him to the rehab for detoxification. And my lord, there is no any other criminal case against the accused persons, and he is young age of 26-year-old.
Now, the other applicant, co-accused, has been released.
Yes, he is granted bail by the special court for NDPS UPR on 10 April 20.
Why it was granted and not to you?
Your Honor, he was granted just because, Your Honor, from his possession, only used syringe was recovered. And for my, Your Honor,
From me,
Your Honor,
the contraband was recovered.
Yes, that is, Your Honor, 0.12 gram, Your Honor. And bail was rejected on the ground of, Your Honor, investigation is initial stage.
How long you have been inside the custody? You were arrested on 5/4.
Yes, I was apprehended on 4th April, but it was arrested on 5 April. And sent to judicial custody on 7 April.
Yes, Mr.
Your Lordship, I have received the CD, Your Lordship. In fact, the accused has been cooperating in also revealing the name of from where the stuffs were bought, Your Lordship. However, since there is a status report of the IO where his custodial, this is not necessary, interrogation is not necessary anymore, Your Lordship.
Not necessary.
With regard to him, all the evidences as well as his statement has been recorded, Your Lordship. and therefore his custody is not this.
Okay. Harness. Jayadaji. You are as a,
This is my private case.
okay, I'm counsel for the petitioner. I have also heard Miss Jeannie Tijina, Lanak, additional EP for the state staff. Para. Earlier, the bail application seeking release of the accused. Bail application filed before the special judge NDPS UPR seeking release of the accused was rejected on 10/5/2025. On the ground that the investigation was still in the initial stage. So this is a subsequent bail application filed under section 483 BNS 2023, paying for grant of bail to the accused. Pauline Lego, who has been arrested in connection with DMKPS case number 49/2025 under section 281, 132. What is this section?
281 is a rush driving.
Okay.
And 132 is assault of criminal force to deter public servant from discharge of his duty.
132 BNS read with section 21A stroke 27A of NDPS Act. Stopping. The case of the petitioner is that, where is the FIR?
Page number 18, Your Lordship.
That based on the written FIR lodged by one SIMA Noor on 5/4/2025. The case being DMKPS case number 49/25 under section same, huh? All those have been registered and the accused was arrested on the same day. Stop. Huh? The allegation against the accused is that he was under the possession of where is the recovery? How much you said?
Recovery memo is
Page number
page
21.
number 21.
Okay. Allegation against the accused is that this is a seizure.
Caesar Weber.
Caesar memo.
Where do we find the amount of
Down below, your lordship.
okay, yes,
In inventory.
that on 4/4/2025. One vial, what is this? Heroin,
This one vial heroin, your lordship.
heroin weighing 0.12 grams were recovered from his possession. Your case is that it was not recovered from his possession. Is it not your case? It was recovered, you admitted.
I'm not admitting, but as per the Caesar memo, it was recovered from me.
Stop, okay. The learned counsel for the petitioner submits that the above one vial of contraband was not recovered from his possession.
As per FIR.
He is only a consumer and not a peddler. And since the accused, since his arrest, the accused is experiencing withdrawal symptoms inside the custody, for which he need an urgent medical attention. Stop. Therefore, the learned counsel prays for release of the accused with any terms and conditions. The accused has undertaken to undergo where do we go? Rehabilitation, rehab center.
Yes.
To undergo treatment. In the undergo treatment for in the rehabilitation center. What you have pledged? What is this?
This is
Okay.
160.
The case study has been received, and I perused the same. Stop. Miss Jeannie Lana LPP submits that after his arrest, the accused is cooperating with the investigating agency. He has He has also given his statement and disclosed all the necessary information to the police. And since the investigation of the case is almost completed, the further remand of the accused is no longer necessary.
Your lordship, if your lordship just reflect that the status of the IO speaks about not necessary of him to be kept in the custody.
Not necessary.
That is the status report of the IO.
Okay.
It may be mentioned here.
Okay. While referring to the status report of the IO, See, further sum is that the, where, in the last, okay,
Last paragraph, Your Lordship.
okay. That the investigation in respect of the accused, the present accused, has been completed, comma, all necessary evidence has been collected, and therefore the accused is now therefore the further custodial interrogation of the accused is no longer required. Stop. It is further submitted that the co-accused in the instant case has already been enlarged on bail. Stop. Para. In view of the above, and in view of the above, and on cause. Just a minute. Having heard both the land counsel for the parties, and on consideration of the case, consideration of the material available on records, and also considering that the further detention or and in the interrogation of the accused is no longer required. This bail application, this the prayer for release of the accused is allowed. Stop. Accordingly, the accused is directed to be released on release on bail, on execution of bail bond of rupees 10,000 with one surety of like amount. It is to be executed before. Bail bond is to be executed before.
Before a special
Okay,
court
to be
in the
executed
PS.
before the special judge. NDPS, Papumbara UPR, with the further condition that the accused shall appear before the eye of the case as and when called for.
Yes.
Okay. The accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or any police officer, that the accused shall not commit any similar offense as alleged of commission of the offense. Stop. With the above, this bail application stands allowed and disposed of. Return the case diary. Okay.
Deeply obliged.
Yeah, that's it. The time to this will be fixed for hearing after 2 weeks.
Okay. The parties are appearing.
For you, body and feel understand reflected on the previous.
They appeared earlier. The respondent did not appear in the earlier occasion also. Service complete. Hmm? What already received?
PCR already received. Right, okay.
Yes, that is there, but then whether the parties appeared or not. We need to ensure. Oh, file wakalat nama. How many respondents are there? There are two. Who represent this? Okay. Who represent one and who who represent two? Among these advocates, U Bori and P Lamgu. They represent both. Just a minute. Not mentioned. They are representing whom in the close list also. What are the name of the parties? Let us see. O Pertin. Kariba. Yeah, both represent. Okay. Mr. Land Council for the petitioner is present. Hmm? Petitioners. Yes. Not, okay. Not in the cause list.
Yes.
Okay. Appears on behalf of Mr. Dicky Pangi, Land Council for the petitioners staff, and no one appears on behalf of the respondent. File code record received. Okay. The scanned copy of the file code record has been received. Staff. Since the party are represented and the record has also been received, let the matter be listed for admission after 3 weeks. After 3 weeks. Okay. There is an interim order. There is stuff. The interim order passed earlier shall continue till the next date of listing. Okay. Yes.
This is a regular first appeal, Your Lordship. In this case, it was dismissed at one point of time, and then we had to file an IA for restoration. Therein, the other side had appeared. One advocate called Remo Riba had appeared, but now it seems that in the main case, they have not appeared. So I think I have to take steps again, Lordship.
Okay.
So if Your Lordship will allow me 7 days time to take steps and have this matter on 18th of June. I'll be coming on that day again for some other matter. Only one respondent, Lordship.
Only one. Okay.
Only one respondent. Passing that.
Oh, not taking.
That's it.
Mr. Sharma, Land Council for the petitioner. Praise for Father. How much time? You say?
1 week time, I'll take my steps and the matter will start 18th of June, Lordship.
Okay.
After 4 weeks.
Praise for Father, 1 week time to take steps upon the respondent. Stop prayer aloud. Stop. Step upon the respondent number respondents.
Respond. Single respond.
By a register post with
Yes,
ID,
yes.
as well as by the usual process. Okay,
Yes, Lordship.
within a week from today. Okay. Stop. Is prayed for. Come on. This matter again on
18th of June, Lordship.
18th June. Okay.
Oblige, Your Lordship.
Lordship, this is IA for staying the. Your Lordship, first, whether the service has been complete or not, that has to be looked into, because on earlier occasion also the IA, they have tried to place before this court, but this court was not pleased to pass any order, because notice has to be, service has to be completed first, my lord.
There is no office, no. In this case.
They've been directed to take steps. Lordship, I have taken a step.
You have taken steps.
Yes, your Lordship,
When?
through advocates clerk, your Lordship. That will not work. It has to, they have to ensure whether it has reached the appropriate block or not, office. In many occasions, advocate clerk miss out all these things.
There is no office note. Mr.
P. Vankani, Your Lordship.
Planning Council for the petitioner, submits, applicant. Submits that he has taken steps, however, the office note doesn't reflect the petitioner having taken steps upon the respondent staff. Office shall reflect the same stuff. You just check if you have not yet taken steps, because you are submitting on the basis of the information from your colleagues, isn't it?
Yes.
So you just check out if step has not yet been taken, you take fresh steps. Okay, you take steps. Okay. The applicant shall take steps upon the respondent by a registered post with AD as well as by user process if not yet taken within a week from today.
Yes.
Okay. List this matter after 3 weeks.
Yes.
Mr. Ether, appear on behalf of the state respondent. What is this case for? Criminal petition.
Yes, on merit matter. On merit, not on settlement, on merit.
Okay.
On merit.
Then we have to ensure the party.
Yes, yes, absolutely.
Okay. Much okay.
Obliging.
Yes.
We have not received the case diary, Lordship.
My Lord, open charge is under section 21A and 27A of NDPS Act.
21A, BC.
And 27A of NDPS Act.
Okay.
Which is held to be bailable by this coordinate bench.
So,
however, our bail application has been rejected by the learned
By
court
the-
below without
okay.
applying the
You
fine.
just produce next week.
Yeah, Lordship, again, we have.
Where the
to
call
submit-
for?
Yes, Lordship, we have already called. This is the W3 message, Lordship. Fall on the same day, Lordship.
Okay.
Next week, Lordship.
What it says?
He says the record may not be
Record may
required.
not be required, my lord, because the main accused party
We do not know.
Yes, Lordship, but during the course of
We do not know.
investigation, yes, Lordship.
We
My
do
lord,
not-
the main-
let the IO speaks. Thereafter, what more they have recovered during the investigation period, we do not know.
Because,
Lordship,
Your
we
Honor,
have to-
since it's held to be
No.
bailable offense, so it's a matter of right. Moreover, the
Mainly,
main,
why it was rejected
main-
then?
main-
Why it was rejected then? Why it was rejected?
it was rejected on the ground that from my CSP, I'm a customer, I'm a CSP runner in Alo Township. And from my service point, some of the
See,
users have
so many
deposited
things
and
will
all.
come during the investigation period. Since the case is still under investigation, some more will come. We do not know. That is why the latest status report is necessary.
Granted bail.
We do not know. That is what I'm saying. We do not know.
By this-
Let the IO speaks.
My lord, in this case, interim, in the next that if it is
Why?
found that,
We-
if in the next that it is anything found, the campaign may be cancelled, but
Miss El Hage.
her 7 years old child is also suffering now. And the wife is already divorced. So at least to look after.
Wife is divorced?
The wife, they have already divorced, the accused
And
has
child
already
is with
divorced. The child, 7 years old child is school.
7 years?
Yeah, is now suffering ill. So at least.
Lordship,
interim bail.
next week, Lordship.
You should have been more careful in that case.
No, my lord, actually, I didn't know whether these users have deposited in my CSP account for drugs and all. My business is as such as anybody can
Okay,
deposit.
let us see the record. If nothing comes, don't worry.
At least a
Miss
conditional
El
bail
Hage
may be granted.
additional PP. Praise for
Yes, Lordship.
submits that you have asked for the scan copy,
Yes,
not
Lordship.
sent to you.
Yes, Lord, scan copy.
She is yet to receive the scan copy of the scan copy of the case, scan copy of the case study of the ROPS case number 14/2025 under section 21A and 27A of NDPS Act, and please for some more time. Mr.
M. Atta.
M. Atta, Counsel for the petition is also present. in view of the above, that will be listed again on
22nd lordship.
27.
22nd to
22nd.
Yes, sir.
On which date, Miss Pradhan additional PP shall produce the updated scan copy of this CD. Okay.
Obliged, lordship.
My lordship.
Yes.
This application criminal petition is filed on the ground that no criminal case has been made out in the FIR. Kindly see the FIR. FIR is with page number 15, annexure 1. FIR is with regard to some agreement with dealing with
FIR
the-
is page
page 15, annexure 1. Kindly read the this FIR. We have come to the understanding that in the FIR, there was, as per the statement of the complainant,
where are you reading
was-
in FIR?
he was-
Which paragraph?
page number 15, annexure 1.
Yes.
Yes. May I read the contents? I have, as per the informant, I have availed the law.
Yes. Where from you have started?
Yes, page number 15, annexure 1.
Annexure 1.
Yes.
Which line?
This is criminal petition, lordship.
Yes. You are reading which line?
From this first sentence of the FIR. This
Okay.
Respected sir, I
Hmm.
avail
Okay, yes.
vehicle loan of 2 truck dumper from Tata Finance Limited, Lakhimpur in the 2019, 2 more dumper in 2021, funded by same finance company under the firm MS Sassin Sales. In the year 2001, Mustaq Rahman, that is I am, from North Lakhimpur approached me and proposed to buy 2 dumpers. After trademark persistent approach, I agreed to sell. That is the issue. That is, I have purchased 2 vehicles from him. And I have already, it was a rate was settled. I have even enclosed the agreement. The per vehicle, it was a 13 lakhs at the rate of second-hand rate, it was 13 lakhs 50,000. Accordingly, out of 13 lakhs, if for the 2 vehicle, it is 27 lakhs. If per vehicle is 13 lakhs 50,000. Accordingly, I have paid already out of 27 lakhs, 23.48 lakhs to the complainant. And 3.5 lakhs is pending to be paid to the
Okay, just a
accused person.
minute.
Pending to the accused person.
Just a minute. Oh, yeah. Let us ensure the party. So who, you are the petitioner and respondent number 2.
Respondent
Who represent respondent
number 2 is, this is the complainant.
Who represent respondent number 2?
No one knows if notice says,
Dada. Yes, I have taken steps. Dada Nigler. This is the complainant. To set aside this proceeding, criminal proceeding, this appearance is required. Even then, I am at this stage,
What is
I am
this?
seeking
Order
Yes,
dated
interim
so-
order.
so communicated to the PP UPR wide memo number so and so by, what is this?
I have taken
Lordship,
steps.
actually, Lordship, what happened, this is for the passing of the FIR, Lordship.
passing of
But on the last occasion, I have apprised before the court that this person, the applicant is the main accused in the FIR, Lordship. And Lordship, this investigation is not even yet completed because Lordship, this accused, Lordship, this applicant,
See,
this
this was way
petitioner.
back in the, see, March 2024, investigation not yet completed.
No, Lordship, because he is apprising the arrest, Lordship, abandoning arrest because Lordship, on the Lordship, this is the order, Lordship. On Lordship 23/12/24 Lordship, he was granted interim bail, Lordship. After that, he was directed to appear before the IO for the statement, but he absconding, Lordship, since then. And again, Lordship, on 14/2/2025, his interim was recalled, Lordship. The bail was recalled. Since then, Lordship, this about this investigating officer, he is, Lordship, trying to arrest him, but he's evading. So how this?
Mr. Dapat,
Yes,
let us
Lordship.
ensure that the respondent also appear.
That is there, but I want interim order, Lordship. That is the
Lordship,
issue.
no,
Because
Lordship, because
as per the
the
various,
case study
various,
case study also beat me, Lordship.
as
He's
per the,
not cooperating with the investigation. How this investigation can be quashed, Lordship? Investigation will not be.
Just a minute, Mr. Tapa. You just cooperate the police, let them record your statement.
that is the
Let them
problem, Lord.
investigate,
In the
we'll
civil-
see,
in the
we'll peruse the record.
Yes.
And so far, since you are not cooperating with the
Record may be
investigation.
called for, Lord. That is, record, that is always there. Record may be called for, but I am being harassed in this civil case.
Whether
This is a completely a civil
Lordship,
matter.
this is Lordship.
In terms of the various apex court decision, when the complainant failed to make out any criminal case,
Lordship,
in that case,
we
civil
do not
nature of
know.
matter.
That is why. Then why should
Yes.
you worry cooperating?
That's
with
why,
the-
Lordship. He
I'm
never
being-
appeared before the
That
IO,
is the
Lordship.
issue. My contention is, I am being harassed out of civil matter.
No, Lordship,
Such
at least
civil
he
matter
should go
matter,
before the IO
I
for
may,
the statement.
I may not be harassed by the police. This is the issue. On prima facie, there is no inducement, there is no, there is, as defined under the language of the
No. Till you are not paid, then it's civil, but then thereafter you have sold it also without paying.
Yes, Lord, there is
Yeah,
material
Then
against him,
becomes,
Lordship.
then becomes trouble.
kindly,
Sold it also, it
kindly,
appears.
kind-
So that is why you clarify before the IO of the case, appear before IO,
kindly,
and then you are not being
Lord-
protected. Okay, bail cancel.
Lordship, let me
Bail
clarify.
cancel.
Lordship, bail, Lordship, yes, it's record, Lordship.
Hmm?
Yes, it can,
Recall.
record, Lordship,
That
because
That bail matter is as per the standing guidelines of the bail matter. Once bail is rejected, that has to be placed before the same judge. That is there. For that, I
Lordship,
am
this
pressing
AB
the
Lordship
bail matter.
connection is AB
I am-
just before the Lordship
That
has
is not an
Lordship
issue. I-
required to
my
Lordship
arg-
see the case
my
study,
argument
Lordship.
is
No, no,
just
one at a
Lordship.
time, one at a time.
Yes. My argument, my line of argument is
Okay.
that complainant has failed to make out any criminal case in terms of the various apex court decision. This is the case. Breach of contract cannot amount to this criminal case. This is a breach of contract. It is not even a breach of contract. I am ready to pay. That is only remaining amount is 3 lakhs plus. And I cannot sell this.
You have a remedy for that.
Yes.
You have a remedy for
Moreover,
that.
I cannot
But then for the
sell
time-
which
for the
is
time being-
vehicle which is on loan.
For the time being.
That is a loan from
for the time
Tata
being,
Finance.
Clarify.
That is why record may be called for and interim order may be granted lawsuit. Otherwise, I have to
Record
suffer.
already here,
Police
Lordship.
is seizing me as if I am a criminal. That
Lordship,
is
this-
Mr. Tapa, you listen first, huh?
Yes.
Just 1 minute, huh? I'll
Yes,
take 1
yes,
minute
yes.
from you. You were granted bail.
Yes, yes,
You did not appear before the eye of the case.
yes.
You did not care to clarify yourself before the eye of the case that this is a civil matter.
Yes.
Had you clarified, then the matter would have end there itself.
Yes.
But then there, you did not cooperate, did not appear, therefore
No.
your bail was recalled again.
Lordship.
Now, how do we know that it's a civil or criminal matter?
Lordship,
There is record
I
speaks that is
I have
civil.
filed already this interlocutory application because for
No, no,
recalling of
no, no.
for
You-
for
Your bail already recalled.
recalling of
And
this
this is not a bail application.
because I was ill.
Okay, anyway.
That is why I could not
Let
report it
the
to the
respondent
police
appear.
station.
Let the respondent appear. Heard Mr. Tapa. Lani counsel for the petitioner. Also heard Ms. Al Hage, Lani ADPP, Stafa. None appears on behalf of the respondent, the private respondent, Stafa. Probably you have to take
Second steps.
step. There is no record of your taking step upon the respondent. Right? Mr. The petitioner shall take steps upon
Respondent number 2.
This was to be listed along with the every record.
Because this is some independent matter because every
No.
as per
You
the
have already
guideline.
taken steps.
Yes.
Mr. The petitioner shall take steps upon the respondent number 2 by register post with AD.
I will
as
verify
well as
that
by-
whether step has been taken or not. I will verify that because I have already engaged.
Okay.
Yes.
Tapasami is that.
Yes.
There, okay.
Why
just
step
a minute.
has
There
not
is
been
no
taken?
record. Okay. The petitioner taking steps upon the private respondent. Mr. Tapasami submits that. Prays for some time to check if he has taken steps upon the respondent. And if not, the petition shall take on the respondent by the register post with AD within a week from today. Okay,
Yes.
list this matter
After 2 weeks.
after 2 weeks. Yes, sir. Return the, this is what? Case diary.
Yes, case diary,
Return the
okay.
case diary to be produced. That's the updated
Updated case diary.
diary on the next date. Okay.
Yes.
Okay.
Apply.
I think it won't be possible to complete the matter. It may be
Yes.
fixed on 21st, 21st May.
21st.
Yes.
What is this matter about?
It is for quashing of the charge that has been
Other
framed.
side is
Is
contested.
so Mr. Kato is also left, I suppose, for Mr.
No,
CBI.
No, other side, whether the other side is contesting or it's
CBI, CBI.
Okay.
CBI, Mr. Kato would be there.
Okay.
my lord.
Due to paucity of time, the matter could not be taken up. Accordingly, we let this matter be listed again on
21st May.
21st May. Okay.
Much obliged.
21st May is
This month, Wednesday.
next Wednesday.
Yes, madam.
Is it so urgent?
Yes, it's long, but because the matter trial is already on, madam.
Okay.
Others will become infectious.
Okay.
Much obliged.
May I please, Lordship?
Yes.
Lordship, this is a CRP, Civil Revision Petition.
Yes. So I think the time is up. What to do? We have to fix next step. What is this?
My lord, here the issue is very limited, only 2 rounds. I'm for the respondent.
Yeah, for respondent. Whether the record has been, have we received the record? No.
No,
Whether the record was called for?
No, record was not.
Not necessary.
Not
Not
necessary.
necessary.
Why? What is this case about? Just
Lordship, the case is, case of the petitioner is there. On 22/10/2024, a KEBA was conducted by the village authority of Liru village with regards to a disputed land. And in that KEBA, Lordship, I was the complainant in the KEBA. And the KEBA has passed an ex parte order despite my letter that I am unable to appear on said date. Thereafter, Lordship, challenging the KEBA decision, I have filed an appeal before the Civil Judge Senior Division Pasigat, wherein the Civil Judge Senior Division has passed an status quo order with respect to the impugned KEBA decision 2010/2024. Thereafter, Lordship, my appeal before the Civil Judge Senior Division has been again challenged by the respondent by filing an appeal before the District Judge Pasigat. Again, District Judge Pasigat has stayed the order passed by Civil Judge Senior Division. So again, I have challenged the impugned order, that is 11/2/2025, which is an order passed by District Court. And I have challenged that order by filing the present CRP.
that the status quo should be maintained. Your prayer is?
No, the matter has already been stayed. The impugned order dated 11/2.
Stay.
Yeah, it has been stayed. Now the matter is fixed for final argument.
Okay, then both the land counsel for the petition, so Mr. T. Tava and Mr. T. Sunil. T. Sunil are present. However, due to paucity of time, the matter could not be heard. And could not be taken up to the staff accordingly. The list is matter again, right?
My lord, can it be listed tomorrow? Because last occasion also it was fixed as last item, so it could not be taken up.
No.
So can it be listed tomorrow as is and listed in the top of the list?
Okay, 22.
My lord, can it be on Monday, on 19?
No.
Because urgency is there, my lord, because of the status quo. I'm not able to enter into my LPC land, my agricultural land. Because I was doing the agriculture
Monday
activities.
is 19.
19.
Okay, 19. 19 probably not yet prepared for this. Yes.
My lord, this matter may be listed in the top of the list.
For this for 19 not yet prepared. Okay. Okay. 19.
19.
Is it okay?
Yeah, no problem.
Okay.
19. No? Deep level.